Hi, can an editorial website share a name trademarked for a podcast? If not, does this mean I need to come up with an entirely different name? Or would it be okay to just adjust it enough so it's not the exact same?
Cool. This is a great question. And just like every good attorney answer, it really depends.
Perfect.
Right. So let's talk a little bit about podcast services versus like editorial website services. And I don't exactly know what an editorial website is. Do you have any idea what he's talking about? Like, do you know that?
I would say editorial website, to me, that means someone who actually edits websites. So like a WordPress maybe, or a company that.
Yeah, like maybe they build websites for folks.
Yep.
Okay.
That's my thought.
Yeah. So what's interesting is that both of these services, by two different companies with the same name, are going to be in the exact same class of services at the USPTO. So quick recap, there's 45 different classes of goods and services at the USPTO. The first 34 are products, and then 35 through 45 are going to be services. Both of these companies are going to fall into class 41, which is educational entertainment services. Well, I shouldn't say that. I was thinking that this was actually like a website that they were protecting in class 41.
Yeah, so maybe it is that, like it's a website collaboration where people come together and share information on the website.
That's tricky. So I think my answer would be no. This wouldn't be a potential problem, unless, of course, the editorial website is about editing podcasts, right? Then of course, it's going to be too close, right? Because you can have a podcast about editing podcasts and have a podcast or a editing podcast service or whatever.
Yeah.
But I think, I would say it's a big world. And so long as that there's no confusion between the parties regarding, the services that each are providing. So your podcast might be about cars and their website might be about editing websites, right? If that's the case, then there's no likelihood of confusion here, even though they're the exact same name in the exact same class.
Got it.
So the presumption would be at the USPTO that there would be an issue, and then the examining attorney would look at it and he or she would make the determination of whether or not there's actually any likelihood of confusion. And I would say very likely there isn't, but if they're in any shape, form related to one another, if they're both about business, for example, or consulting services, then it's gonna be a problem.
Okay, we've got the Bold Inventor podcast. Oh. If there were a website out there talking about a collection of inventors getting together and they call themselves the Bold Inventor website, you don't have a problem with that, right?
I do. That would be a problem.
Okay, because it's about inventors.
Because it's about inventors. It shares like a subset of, individuals essentially who it's geared towards or the topic's about. Okay. So, as long as those topics are going to be in different spheres, right, then we should be okay. But Bold Inventors podcast, Bold Inventors, workshop, too similar.